I've spoken at several events with a lot of cyber folks who are justifiably concerned, like, are you coming for me, right? Like, we're doing the best we can. We don't want to be in trouble with the government under this very, aggressive statute. We don't want to be, by the way, if you're found to have violated the SA, you're paying back what you stole times 3. Treble damages statute, so my relator can get between 15 and 30%, depending on a lot of factors. So even if they got a full 30%, the government's still getting double damages. They're still getting back twice what they stole, and the bad guys are the ones footing the bill, which is the way it should be.
I am elated because today I have Julie Bracker joining us. She is a partner at Bracker Marcus law firm. And we're going to be deep diving, talking about whistleblowers. Welcome, Julie.
Thank you. It's great to be here. Looking forward to my favorite topic, the False Claims Act.
I find it a very enlightening topic. It's interesting, to say the least. You were on Jacob Hill podcast, and I was like, wow, Julie, she really loves talking about this. She's passionate about this topic. I got to have her on our podcast.
It's even more interesting for me. So my husband is a privacy data security attorney. So he's in-house with Cox Communications right now, but he started life at Georgia Tech doing databases and then was a consultant. So he was in technology for like 25 years before he went back to law school. So I have been the +1 at so many cyber events in my life. When the Cybersecurity initiative was announced in the False Claims Act area, my husband called me. He's like, our worlds are finally going to overlap. This is amazing. So it's been really interesting to get to know the cyber community from more inside it instead of just as the +1.
Yeah, that's certainly some synergy there. Okay. And I always wonder with attorneys diving into the technology and CMMC, for example, they have to hire external IT consultants, but you have in-house.
Between him and all of our other cyber friends, I definitely have a leg up in the area. It really pushes you, though, because I've heard people talk about CMMC and this sort of thing, forever. But to actually be able to explain it to the government is it's one thing to hear the word, it's another to have to actually explain it. So it's been really interesting for me to get to know a lot more about what I've been swirling around my head all this time.
Before we dive deep into that, what do you like to do outside of work?
I love my job. I love what I do. It's so much fun. I have 2 kids. So I've got a 19-year-old daughter in college and a son who's 15, who's in marching band and keeps me busy with that. I love to read. That's kind of boring, but true. I love to read pretty much anything. And courtesy of my gaming geek husband, I do a fair amount of computer gaming. Again, more of as a +1, but I enjoy it. He's also an Audi racing aficionado. So I go along on a lot of those North Georgia mountain trips with the winding roads. That's fun too. Or I stay back in the spa while he's doing the mountain trips. But yeah, I'm a big fan of the North Georgia mountains also. Yeah,
certainly an active lifestyle.
Busy for sure.
Busy. Awesome. So Julie, how'd you get started in law, especially in this area of law? False Claims Act.
I took a long and rambling road to get to law in general. I started as a research associate at Vanderbilt in psychology, and then I went into education. I was doing educational research, and then I went from there to Fulton County Schools and taught, and then was the math curriculum coordinator, and then went to law school. And in law school, I really needed a break from education. I needed a break from not teaching, but all the other stuff that comes with teaching. So I went into what's a tactful way to say dry and boring? I went into an area of stockbrokers and securities, and there's people who are really passionate about that, and more power to them. But I did that for 4 or 5 years in a firm in Atlanta, and then around the time my daughter was 18 months or so, I was looking for a change. Was either going to need to move downtown or hire a nanny or make a change. And I wound up with a boutique law firm very close to home that did False Claims Act work. So that started in 2006 for me. And Jason and I started our firm, frighteningly enough, that was nearly 10 years ago. I can't believe that. I'm a one-trick pony officially. I've been doing this and only this since 2006. I really, really love the practice.
Wow. Okay. Tell us more about False Claims Act. What does that entail, and why do whistleblowers need attorneys like yourself?
Well, the law says they have to have attorneys, which is probably a good thing, because the False Claims Act is really unusual in jurisprudence. If I hit your car, then we can settle that case. But if I see someone else hit your car, I'm just a witness, right? The difference in the False Claims Act is that it lets the witness file the lawsuit. And the idea is that you're the government, not Derek, and you have so many cars, you don't know who's hitting your car. So somebody who witnesses it can file the case and bring it to your attention. And that's the hub of the False Claims Act. It's a historic statute. It was actually gotten a lot of more press, especially with the cyber initiative in this community recently, but it's been around since the 1800s. It was called Lincoln's Law, and it was originally passed because of the war profiteering that was going on in the Civil War, where unscrupulous people were selling things to the United States government that weren't what they were supposed to be. Uniforms made out of tissue paper that would tear when they got put on, flour mixed with sawdust to make up the bulk of it, so it's just unusable, just crazy stuff back then. And just as the telegraph was starting to take off, not like we could just tweet out, hey, who's the jerk who sold us the flour with the sawdust? Nobody knew. The idea of the False Claims Act was that somebody who was involved, an insider to the fraud, if they turned it in, then they could receive a reward. I have defendants from time to time, defense counsel who'll say, well, your client was involved. And I'm like, so? That was the whole purpose of the statute. Typically, most whistleblowers are not deeply involved in the fraud. But you will have people who, maybe they're the biller who would put in the wrong code, and maybe they knew better and maybe they didn't. But, people who are told by their boss to do something and then execute it and then worry about what they're doing. And then they eventually find me or one of my colleagues and they want to tell the government, like, what's going on. Those people are specifically encouraged to come forward. So just because you've been involved in it doesn't mean you can't be a relator. I wouldn't say that the exception is for people who are the architect of the fraud. If you came up with a whole idea, you can't do that and then turn around and
try to profit from it.
That's right. Which is kind of where, the idea of, but your person was involved. Rarely are they the ones benefiting, if that makes sense. It's usually maybe they're helping execute, but they're rarely benefiting from the fraud. But the whole idea is if someone has stolen money from the government or has lied to do that or has lied to keep money they weren't entitled to, then they violate the False Claims Act. And my clients are called relators because they're relating the fraud to the government. They're the witness.
Oh, okay.
And the case is not about my client. The case is about the defendant and what they did vis-a-vis the government. How did they treat their government obligations, particularly, when we're talking in this context, their contract obligations with the government. You can have an ordinary breach of contract case. Julie promised to sell Derek 10 widgets and I only gave you 8 widgets, breach of contract. Or, I gave you widgets, but they're defective, breach of contract. But I gave you 8 widgets and I didn't tell you that they were, defective, but I knew they were defective, or I should have known they were defective, and I passed them off as widgets. Now it's a little bit more than an ordinary breach of contract case. We're getting into fraud, waste, and abuse. And, I really think that's critical to understand about the FCA. I've spoken at several events with a lot of cyber folks who are justifiably concerned, like, are you coming for me, right? Like, we're doing the best we can. We don't want to be in trouble with the government under this very, aggressive statute. We don't want to be, by the way, if you're found to have violated the FCA, you're paying back what you stole times 3. Treble damages statute, so my relator can get between 15 and 30%, depending on a lot of factors. So even if they got a full 30%, the government's still getting double damages. They're still getting back twice what they stole, and the bad guys are the ones footing the bill, which is the way it should be. But it's not punitive in the sense of a punishment, in the sense of legally punitive. But when you look at these very aggressive damages that the government is going to get if you're found to be in violation, then people are justifiably concerned that they don't want to run afoul of it. That's perfectly understandable and not likely if you're trying not to run afoul of it, because the people who get in trouble under the statute are the ones who know full well that that's a widget, not a widget, or people who promise to do something and then simply don't do it. That's the kind of mindset, which in the law we call scienter. So fancy lawyer word for your state of mind. It has to be knowing, and then knowing is, of course, this is law, so we define that word too. It has to be you knew or should have known. You can engage in reckless disregard, right? In other words, you can't bury your head in the sand. No, I hear nothing, I see nothing, and then claim not to have known better, right? It's a little bit like getting pulled over by the cops and you're like, I didn't know the speed limit was 45, right? That's not going to fly when you should have known.
Right, makes sense. So ultimately, the relators, ones who are filing the complaint, notifying the government, ultimately they're trying to do the right thing because they feel that the government is being defrauded. Now, you did draw the distinction between where it can cross over to fraud, waste, and abuse. What are some examples of that?
The False Claims Act was mostly a military statute, defense contracting statute in its inception. I told you it started with the Civil War. And then somewhere in the late 90s, some people said, you know what else is a contract with the government? Medicare. And suddenly the medical aspect of the FCA really blossomed, took off. And I would say from the 90s through, well, even now, I think Medicare, Medicaid dollars, healthcare related fraud is probably a solid 70 to 85% of False Claims Act cases. So, in part that's because there's so many healthcare providers who take part in that program. We spend billions of dollars in the healthcare sector.
Right.
Now we're kind of coming back full circle with the Civil Cyber Fraud Initiative, which was announced in 2021. The occasion for my husband making that phone call of, oh my goodness, we're going to finally overlap, where the government said defense contractors, and that would include those who are, have a grant from DOD or one of the branches of the military.
The universities as well.
Of course. If you've got a contract including a grant with the government, you've been required to certify that you're in compliance with the NIST standards, whatever's appropriate for the level of information that you might be receiving. You've been certifying that you're compliant with that since January 1st, 2018. And basically the government said, we know you're not doing it.
Right.
The government has the problem of hearing about cyber incidents through the news that don't get properly reported. So they're like, we know you had one, but you haven't reported it. And they don't have any good way to force compliance with those standards. And someone, I don't know who, but bless them, pointed out, we have this wonderful statute. And the great thing about the False Claims Act, it's the number one tool for fighting fraud. It recoups billions of dollars for the government. It's always been interesting to me that someone who would not dream of stealing my car, if the government sent you a check for $100 would go, okay, they would cash it and keep it, right? They don't feel like they're stealing in quite the same way as if it was another person or even a company. How much of that is because they think they can get away with it? I'm not sure. But in this instance, you had people saying, we got to do this thing. We got to comply. And they would ask, internal IT people who were not cybersecurity trained to look at whether or not they were compliant with the NIST standards. And I'm sure y'all have looked at them a lot more than I have. They're like the law. You say knowingly, but it doesn't mean just knowingly. It also means that's a word that is kind of an iceberg in the law, right? When we say knowingly, we mean know or should have known. And there are a lot of things in the NIST standards that if you don't know what it means, you can try to puzzle it out, but you're going to miss things. You're going to not really understand what's there. So we had people giving themselves scores. That's pretty good. We're at like 78.
We're passing.
Yeah. And then when the Civil Cyber Fraud Initiative was announced, the government said if you are lying about compliant, if you are non-compliant, or just being non-compliant with something that you've certified compliance in is a violation, and you're on the hook because it's been since 2018. Peeps, you ought to know this by now, right? Get this under control. If you misrepresent your score, for example, in the SPURS database, you put in a number that's not accurate, that you should know is not accurate by this point, people, or if you fail to report a material incident in a timely fashion, then all of those are going to be, they're material to our contracts with you. In other words, we care about this. This isn't something that we just kind of tacked on like all that stuff at the back of a contract that says, we comply with this and we buy American and we do all this other stuff. This is something that we will consider to be a material breach of our agreement if you don't comply with these standards. And you said earlier, whistleblowers are people who don't want to see the government defrauded, and you're exactly right. But my cyber relators have an even bigger responsibility. They're concerned about state secrets. They're concerned about, foreign threat actors getting access to our IP. They're concerned about protecting people's private information. It's a whole different level of concern. It's not just money. There are things in the clear that shouldn't be in the clear. And after struggling internally to get that corrected, they feel like they don't have another place to go, and they report it, which is really the thing that as good citizens and Americans that they should be doing.
Right.
They're protecting me and you.
Yeah. A lot of defense contractors, people that are working for defense contractors, do have a high level of patriotism. They care about what they're doing. So I think that's a good segue into the most recent False Claims Act in the cyberspace. It kind of shook everyone with the Georgia Tech. Can you tell us an overview of that case?
Sure. The Georgia Tech case alleges it's the same sort of, and it's publicly available, so I'm just kind of telling you what is in the clear. The two relators in the Georgia Tech case exactly the experience that I just related, which is the same as Matt Decker had in the Penn State case, who's also my client. So Georgia Tech was filed first, and then Penn State came out from under seal first. So people heard about it first, but it's actually the second case that I filed as between the two of them. So in the Georgia Tech case, very similar to Penn State, both sets of allegations are basically that you have a research institution who is ingesting, storing, perhaps creating a CUI, and rather than properly protect it, the university was letting the different principal investigators, PIs, kind of steer their own ships. So you would have the principal investigator, who is a researcher, in most instances is not a cyber expert, who had a system administrator who is an IT guy. He's not a cyber expert either, or she. And they would have the sysads say that things were compliant with NIST when they didn't really know whether they were or not. They did not take the time to understand what the regulations meant, what they required. And so they were giving themselves higher scores than ought to have been. So my relators were in IT and had some concerns about it already, had raised them internally, fairly routine matter where they needed to make some changes in a laboratory environment. And when they got in there, they realized, it's all in the complaint, something to the effect of, I need you to take down the firewall so I can do it. And it was, we ain't got no firewall. And then they're like, what? So kind of, went from there. And here we are. So the government intervened in that case in late February. So it's now out from under seal. The government was given 4 months to draft its complaint in intervention, which means they've intervened in the case at the end of an investigation, which can go anywhere from, 60 days to, I had one that went 10 years.
Wow.
It varies wildly. However long the court will give them latitude to keep investigating, and depending on, in a lot of cases, it'll be extended because of change of personnel at the government, whether defendants are cooperative. There's a lot of factors that go into how long an investigation lasts. But at the end of the investigation, the government either has to intervene in the case, which means they take it over and litigate it, or they decline. And if they decline, then the relator has the opportunity to go forward, still standing in the shoes of the government. So now I've told you that someone hit your car and I've sued them on your behalf, and now I'm suing them without you, right? I'm still going to have to give the money to you, by the way.
Wow.
But I'm still pursuing that case for my share of it. And, the government can decline for any number of reasons. It does not mean the case is not a good case. In fact, they intervene. If you ask them, they'll tell you like 15% of the time. If you ask me, I'll say more like 10. That difference is because they count the times when they decline, let the relator litigate a while, and then intervene, a late intervention, which happens, I won't say frequently, but more than none. In any case, at the point where the government intervenes, then the government is taking first chair and they're making the decisions about the litigation. So they're right now drafting their complaint and intervention. That'll be filed. And then it's like the lawsuit just gets started. That's where we'll be starting with discovery, depositions, all of that sort of stuff.
So during the DOJ's investigation to prepare their report, they're not necessarily doing any discovery. That's not really part of their investigation.
That is definitely part of their investigation. The government investigation is sealed. So that's the distinction, is that while the government decides if it wants to go forward, the defendant doesn't know for sure. In fact, they don't know it all to begin with, that there's what's going on. Obviously, the government can do investigations all by itself. They don't need a relator. They can even file a False Claims Act case on their own. If you were a relator, then the case would be styled U.S. ex rel, which means by the relator, there'll be U.S. ex rel Phillips. Whereas if the government brought it itself, it would just be U.S. versus Georgia Tech or whoever we're suing. So you can tell if there's a relator by looking at whether there's an ex rel at the beginning of the case name, but they don't have to have a relator to file a case. During the investigation period, what the government will do is send out civil investigative demands, which is basically a government subpoena, CID, that says, we want to see your documents pertaining to X, Y, and Z. And depending on what the case is about, that could be, any number of things. It'll usually include some email requests. It'll include the pertinent documents for each contract, whatever they need to begin to establish whether relator got it right or not. So they're looking for, you've got testimony from the relator. Sometimes the relator has documents. Even if the relator brings documents, smoking guns, they're going to want to see the version that the defendant has, sort of verify what the relator is telling them. At some point, they will typically ask for a partial lift of the seal, which means that they bring the defendant under the seal as well. So they'll be like, okay, you are indeed being sued under the False Claims Act, and we have a relator. At that point, they're usually ready to say, we think you did it, and this is the damage. And, the defendant will come back and say, typically, we didn't do nothing. If we did, we didn't mean to. And if we did and meant to, it didn't cost that much, right? So they'll do their defenses, and at the end of the day, it turns into number swapping, and they see if they can get it settled. And that's a very high overview, and I'm not usually involved in that process anyway, because that's the government settling its own claim.
Okay.
That's where I've told you somebody hit your car, and you're talking to them about that.
Right. So with the Georgia Tech case, now the DOJ has decided to intervene. Have you had other cases that you have filed that the DOJ has intervened in?
Oh, yeah, for sure.
Yeah. Okay.
Yeah, we have a pretty good intervention rate at my firm. Way better than the national average. Partly that's because we've done this for a long time. So we're pretty good at sussing out what the problems are going to be with the case at the front end from a legal standpoint and putting the package together for the government. So sort of be partners with them and how to do the investigation. Like if you can explain it all at the front end, then it makes it really clear what you need to go after. At least that's our goal.
Connect the dots, certainly.
Right.
Now, what has been your experience working with the DOJ? Has it been an overall pleasant experience? And have you ever had them intervene and force a case to be dismissed?
I've had a great experience with the government for my entire career. I can't not been sideways with the government that I can recall at all to any significant degree, partly because, and not all relators counsel feels this way. This is Julie's philosophy that you're the one whose car was hit. If you look at it and tell me you don't care, then I'm not going to go after the person who hit your car if for whatever reason you don't care. Now, like I said, they will decline for a lot of reasons, some of which may be like manpower, some of which, they've got a finite amount of resources and all the fraud cases that are brought to them. So, we are currently litigating a case, Jason and I are litigating a case against a small doctor's office with what we allege is very egregious fraud. It's a small doctor's office. The recovery is not going to be that big. The government can't really put its resources on that kind of case, but we're more than happy to step in. Now, the difference would be if the government declines and says, and this has happened too, we recognize that what they're doing, we see what they're doing. We've seen it in other cases, and this will often happen with like a clever new way to code something in the medical context to get paid more, right? And I'll say, we see what they're doing, and we're doing a regulatory fix. We're going to change the regulations to make it clear that that's not acceptable, right? So
close that loophole.
That's the word, right? That we see that as a loophole in our regulations. We don't think it's strongly enough stated that it could be fraudulent. We think they're exploiting a loophole. And I may disagree. I may think it's perfectly clear. But if they're in the midst of a regulatory fix, the last thing I need to be doing is fighting them while we're going to have to prove, if you're the bad guy, Derek, just to give you use you as an example.
I'll be the bad guy.
You're the bad guy. If I say Derek is billing XYZ and he shouldn't be, and they say, yeah, we know Derek and a bunch of other people, and we're closing that loophole. And then I try to persuade a jury that you are not exploiting a loophole, that you're committing fraud, then what you're going to do, or your lawyer's going to do, is say, look, everybody's doing it, and it's not fraud, it's a loophole. And we know it's a loophole because they just fixed it. And, that's a bad case. I only get paid if I win. I'm not going to take that. You referenced the C2A dismissal is the part of the statute that says the government can intervene and dismiss a case. And we've had a lot of litigation about that recently. It went up to the Supreme Court. When can the government dismiss a case? Do they have to intervene in the beginning if they're going to dismiss it? We've had a lot of litigation about that. And it's interesting because it was like such a big deal in the news, but to the relators bar, really not so much. We don't get paid unless we win. I don't want a case where I'm fighting the defendant and the government, right? That's silly.
Right.
I mean, that's my technical legal term. That's silly. So I've never been afraid of having the government move in and dismiss one of my cases. Long before that, they're going to tell me, Julie, we don't think this is a good case for you to pursue, and here's why. And I'm most likely going to listen. You can envision a world where there's a reason not to listen to them. If you had some corruption in the government, and that's the reason why there is the process, that the government can't just dismiss. They've got to talk to the court about it, right? They have to move to dismiss, and the relator gets a chance to put on the case as to why they shouldn't. And I know where relators get frustrated, and this has happened to my colleagues. They've pursued a case a long time. They've invested a lot of money and time and energy for this case. And, like I said, we don't get paid if we don't win. And then the government says this is a bad case, and then they want to dismiss it for whatever reason, political, typically, right? And that would be super frustrating for those of my colleagues who do litigate a lot of decline cases. I can imagine that would be very, very frustrating. But it rarely comes without a story. When were you first on notice? Please understand, I'm not criticizing those people who've been in those fights, because there's always a story. There's two sides to it at least, as to why the relator pursued the case even without the government's support. But compared to the number of cases filed, I think it's a fairly rare discussion. And it's not something I worry about.
Okay.
The government will swoop in and dismiss my case.
Understood. Yeah, it makes a lot of sense. And me being a compliance geek and deep into CMMC, I remember it was a Saturday afternoon when I was at a kid's birthday party with the kids, and someone that I follow on LinkedIn as an attorney, first name Stephanie, she had posted about the Georgia Tech case being unsealed. And I spent that Saturday night reading through the entire complaint, taking notes, just really like, wow, this is interesting. But while I was reading through it, I was wondering, like, for you as an attorney, when a potential prospective client comes to you, let's say in the context of CMMC, and say, hey, I think we have a False Claims Act case here. I want to be a whistleblower. What elements do you look for to know whether that's a good case or not?
That's a great question. I'm going to say, for starters, really want to make sure people understand this. If somebody does worry, right now they're worried about noncompliance, especially when there's national security risks, it is completely confidential to consult with me, and it is completely up to you what happens after we consult, after we have our consultation, and it's no charge. So reach out to me. We can have a conversation about whether I think it's a good case. Sometimes I do say it's not a good case, and here's why. And it may be that every fact you told me is, even taking it all as true, I don't think it's a good case, and here's why. And then at least you have your mind put at ease, right? And although if you call me up for a consultation, I don't become your attorney until we do an engagement, but I am bound by attorney-client privilege for that conversation. No, I'm not going to tell anybody else. It's all attorney-client privilege, and the ball is in your court after that as to what you want to do. But here's the kind of thing I'm looking for. I'm looking for cases not where I was on a panel and I had a defense attorney say, so you're saying that somebody could violate the False Claims Act just by not having two-factor authentication. And I said, well, if the only problem there is there's no two-factor authentication, that's a terrible case. I'm probably not going to file it, right? Yeah. On the other hand, I have a hard time seeing a situation where there's no two-factor authentication and that's the only thing they're doing wrong, right? Just that one weird slice of things. So it's going to be what's being violated. That's, question number one. What are you not doing that you should be doing? Another question very tied to that is, how do I know that's what you should be doing? So if you're a DoD contractor, then the DFARS and the FARS provisions have incorporated the NIST standards, and it's really, really clear. If you are not a DoD contractor, what are your obligations? And to understand that, I've got to either look at the contract, if this is a contractual issue, or whatever the governing standards might be for your space. And the less clear the obligation is, the mushier the case gets, right? Okay. And that's not to say that I wouldn't file it. I filed a couple of cyber cases where it is kind of squishy. Another question would be, are you a public company? Because the SEC has its own requirements now for incident reporting, right? And so I will look to the governing standards for the situation that you're in, and that's partly a lawyer job and partly a fact question. So I have to talk to the potential relator about that. So it's, what is your duty? How have you breached it? And who knows this? And you can see, if you read the Georgia Tech case, they sent up so many
file complaints, everything, formal complaint,
everything to try to get it done internally. And, we want that. And for the most part, not always, but for the most part, my relators have already reported internally quite a bit before they get to me. They're mostly people trying to do the right thing, and they're concerned because this is the wrong thing. So they're worried about the security aspect of it. They're worried about the secrets aspect of it, and they try to get it changed. If you look at U.S. ex rel Decker, the Penn State case, you'll see the same kind of behavior.
Yeah, right.
And when people turn a blind eye, I personally see this pattern repeating a lot. Cybersecurity starts to get national attention. companies that contract with the government go, this is the thing. Maybe we shouldn't just be relying on our sysad. Maybe we should actually hire a cybersecurity expert, especially with CMMC coming. We may have to expose ourselves to third parties eventually. We better start doing something about this. So they hire someone who actually knows cyber. That person comes in and looks under the hood and goes, good Lord, this is not a 70. This is not a 70. And you're going to need to, for example, you can't be on Azure Commercial. You're going to have to be on Azure GCC. And the dollar signs start rolling like what's it to comply. And it's not the cost of hiring, Derek to come in and do the work. It's the actual cost, hardware and applications and moving things over and the lift and shift and all this kind of stuff, hardening the systems. All of that comes with a price. And cases I'm seeing, they're not prepared in the C-suite for the price. And they really don't want to invest it. And then my relator is left kind of holding the bag. You asked me to come remediate this, and now you won't let me remediate this. And now I know what's under the hood. And I know that we have national secrets exposed to foreign nationals. We're not doing what we said we do. And like you said, a lot of, not just patriotic, I've got a lot of former military people who are like, I put my life on the line for this country. I'm not going to, stand by while these yahoos refuse to pay to secure when they've already said they did. That's a great case to me because they know and they've made a knowing decision not to do it and they're in violation. That is the quintessential case to me. And you'll notice that didn't involve an incident at all. I'm relators counsel, so I'm going to call it a breach. A lot of people like to call incidents. Right? Yes, if there's been a breach, then that makes it easier to calculate or at least to think about damages because you sort of instinctively want to say what harm comes from my noncompliance. Well, the whole point of the cyber fraud initiative is to say the harm is that you've lifted exposed, right? There may be further harm if there's an incident related to your failure, but your failure to secure it is itself a violation of the False Claims Act. And so I'm not only interested in cases where someone is not reporting a breach, although that is certainly I've got one of those. It's not that, but that's not the only thing, right? If you're just failing to secure, I would love to remediate it all before we have any breaches. That's my goal is not a big juicy breach. It's to secure the information for the government.
Okay. You mentioned earlier about like maybe falsely attesting to compliance. And we talked about SPURS. What are some other ways that defense contractors in this example can basically falsely attest their compliance if they're not directly submitting SPURS score?
Well, that's where I would look to their contract. What did they say they would comply with? Because when they submit a request for proposal, if there's a request for proposal out there that they submit to, or if there's a grant that they've applied for, then it's going to say what they have to do. You may have to go all the way back to the request for proposal that the government sends out, but you want to look at the underlying documents of the agreement. What did you say you would do? If you say you'll do it and you don't,
so it's not optional.
Right. In the law, that's called fraudulent inducement. I've induced you to contract with me, and I lied when I did it. That's pretty quintessential fraud, right down the line. So.
Okay. Got it. Doing the intake process, when you first having those early conversations with a prospective client for a cyber-related False Claims Act case, what discovery tools are at your disposal so you can kind of see if they're telling the truth?
Yeah. Well, some of that is more art than science because I've been doing it a long time, right? There's no formal discovery available to me. I can't request documents from the defendant or take a deposition or anything like that. So there's no formal discovery at all. Some relators counsel, there's a delicate balance you have to walk between you want to be able to verify what you're being told by the relator, and at the same time, you don't want to put the defendant on notice that you might be filing a lawsuit. Because the whole point of the seal is so that the government can do its investigation covertly before, so that nobody's, a la Enron, trashing documents, right? You don't want to give them a chance to do a cover up, to threaten witnesses, to do all of which can happen. And so importantly, you really don't want to go too far down that path. So sometimes we talk to other witnesses. Sometimes there's, in the Georgia Tech case, I have 2 relators. In the Decker case, I have 1. They sometimes have, emails and documents. I'm allowed to look at them for purposes of whistleblowing. Even HIPAA has a specific exemption for whistleblowers. So you're allowed to seek legal advice about those documents. I have to be careful, and I would guide someone through this process. If you have documents that are attorney-client privileged or arguably privileged, where the company's lawyers are copied, I don't want to see those or hear those or talk about those, which is another reason why an incident case is harder. As soon as there's an incident, a lawyer's name gets slapped on the paperwork, whether it's really privileged or not. They'll put the lawyer name on there, and then we have to, have a court decide whether that's really privileged or not. So we have to be careful about that. But at the same time, we will look at what documents are available to us. A lot of it is just plausibility of what I'm being told. People rarely come to me who are excited and happy to be filing a case.
So they're frustrated by the time they get to you.
Frustrated, they're stressed, they're worried. If someone comes in and they're kind of excited, then I'd be kind of a little more, what's going on here? That's why I say it's more art than science. You can verify fairly easily whether someone really knows what they're talking about or not. Even at my level of expertise with NIST, what are their credentials? What's their story? These are the kind of things I look at. So I am a very cheesy patriot myself. If there is a chance that servicemen or women are being put in jeopardy by what you're telling me, I'm going to file it, even if I don't have the documentation I might need to establish it. And then what I'm going to tell the U.S. Attorney's Office is, I'm bringing this to you because servicemen and women could be in jeopardy. If you tell me that they're not, no problem, we'll dismiss. But I want someone at the government to be aware and taking care of safety of our troops. And so I have a much lower threshold for those cases than I might for a medical case, unless it's a medical case where patients are in jeopardy. If there's a chance of something besides the money going on, then it's going to depend how likely is it that someone is being hurt, injured, put at risk. And that's going to factor into the decision as well.
Makes sense. And to that point, so I've read through the Penn State complaint and also the Georgia Tech complaint. I do notice that common theme where those realtors were raising those concerns internally first. It was a track record or at least a trail of whether it's emails notifying their superiors, or in Georgia Tech where it was an internal ethical complaint process that they follow. So I'm sure for you, those are all things that you look for. Like, okay, this is a stronger case because they can't say they didn't know.
They can't say they didn't know.
Right. On the defendant side, mentioned a lot of our listeners do work for a research university. So I'm sure they're concerned, how can they avoid being the defendant in this type of false claims complaint? What are some tips you would give them?
My number one tip is to not defraud the government. I have no interest in you if you're not defrauding the government. So, I'm being silly, but I'm also not being silly. People, corporations, research institutions that are genuinely trying to do the right thing are not going to be my defendants. I'm not casting aspersions on the ones that I have sued, because this is a corporate question, right? Do I think Georgia Tech people are evil? Of course not. Do I think that the institution should have responded differently to my 2 relators? I certainly do. I absolutely do. When you see the pattern in both of those cases of the refusal to listen to your internal complaint, you need to have a robust system for people to report internally. You need to take them seriously if it's their area of expertise. I would venture to say that in both of those cases and the other 8 I filed, if the internal folks had listened and started trying to fix it, they never would have come to me. This is, as you just said, born of frustration, born of a failure internally to listen and address the problem. And if the real problem is we can't afford to do that right now, I don't think that's really the problem. Affording it in the commercial context, and this applies less to research institutions, but certainly in the commercial context, we can't afford to do that without affecting our profit. Is not an acceptable answer. But if the genuine answer is yes, we need to do that, and we have a plan to do it, the beautifully named poem process is available. Just don't lie, right?
Okay.
Don't lie. That's huge. If you've got a -12, put a -12 in there, and a poem that says this has come to our attention and this is how we're going to remediate it. And no one expects that you will remediate overnight something that's going to take a lot of time and money to fix. But now you're not in a fraud situation, right? This is not me handing you widgets and telling you they're widgets. This is me saying, I've got a problem with my widget. Let me get back.
But I'm working on it.
Exactly. And I think that companies who do that, not only you're going to avoid my interest, you're also in a good position to talk to the government. There's been a settlement Verizon settlement under the Civil Cyber Fraud Initiative where they reported it. They self-reported.
Self-report.
And because they self-reported, they only paid double damages, right? Actually, I don't know. I can't even say that because it was a settlement. So I don't know how they arrived at the numbers. But there is a provision of the FCA that says if you self-report, you only pay double, not treble damages. And there's a concept called cooperation credit the DOJ has. It's in the DOJ manual. You can find it online. Where if the defendant is cooperative, I've listened to several assistant U.S. attorneys talk about this, and they say cooperative is not producing documents under subpoena, right? That's required. Cooperative is, volunteering, coming forward. Maybe you get a government subpoena that alerts you to the fact that CID, Civil Investigative Demand, maybe you get that and it alerts the company to the fact that there is a problem. Then you need to go, holy moly, we found a problem here, folks, and be forthcoming, not merely complying with your discovery obligation. That will help too. Even if you're already at the investigation point, that will help too.
We mentioned forthcoming. CMMC is still in rulemaking, and DOD is anticipating it being finalized Q1 of next year. Do you foresee more False Claims Act cases related to noncompliance with DFAR 7012 as a result of CMMC being a final rule?
That is a very interesting question. We generally have sort of waves of FCA litigation in areas when, I'll give you an example, Buy America. We have Buy America cases, and we still have some because people just won't get it together. Once the government has said, yeah, we care about this provision in our contract, we do expect you to buy American, then people kind of go, oh, rats. And then they start complying. It's going to cost us more, but they mean it. And so they'll kind of drag over into compliance. I think the intent with the Civil Cyber Fraud Initiative and my expectation as a practitioner is that we're going to see, as these cases come out from under seal, like you spend a Saturday evening reviewing the complaint. If you're in this space, if you are a CMMC provider, then you're going to say you have that in your bag of tricks when you hawk your wares, right? Like, you need this because you got to do it. You have that whole thing right now, like winter is coming, whether it gets here in Q1 next year or not, I don't know. But the fact that it's coming has been what I think started the buzz. That's the people getting towards compliance. I don't know that it will cause more. I think it will cause different. It'll be less, oh, look, we've had Bob the IT guy has given us a score of 95. Congratulations. And it'll be more like, well, when CMMC came in, we only showed them the enclave. We didn't show them where all the other stuff is.
Yeah, I'll certainly see it. See that happening.
Scoping or what is certified won't be quite where the data is actually kept. That would be an example. I'm sure there'll be others because people are infinitely creative when it comes to fraud.
That's a really good point. I certainly can foresee that happening. Yeah. NIST SB 800-171, it's not prescriptive, so it doesn't go into details about the scoring requirements and so forth like that. Essentially, it leaves that flexibility to the federal agency. So in this context, the DOD, where they're saying, okay, this is how we're handling scoring. You have to have all 110 practices implemented. What do you say to companies and where we're saying pretty much, well, since NIST doesn't say the scoring has to go a certain way, CMMC is not going to happen, so I'm just following this, and I'm going to pretty much handle it my way versus following what DOD says. And they're a DOD contract.
I think that's risky because this is choosing to bury your head in the sand, right? So I said knew or should have known. Do they know that it has to be done a certain way? Not yet. The question would be, is it obvious that their interpretation is not the standard interpretation? And that because that playing fast and loose and pretending you don't know what the industry is doing, closer we get to CMMC, the harder that'll be to sell to anybody. Yeah. Does that make sense? Like, like, as once it's, good luck once it's passed. And keep in mind, I would also say to them as just a business thought, keep in mind that if you're wrong and it does pass, you've got a lot to catch up on. You'd be a lot better off gradually complying. You had from 2018 to 2021 before the Civil Cyber Fraud Initiative. So it's really hard to say that you didn't know by the time we get to 2021. With cases coming out from under seal, you kind of have to put your head in the sand, which is the definition of one of the knowinglys under the False Claims Act. So I would say just as a business decision, it doesn't make much sense to not get compliant, to at least be working towards that, because there's an inevitability about it. I don't even opine, will it be CMMC? What will it look like? But I do know that there is coming some sort of standardization with certification with third-party auditors. That seems inevitable. That's the way it is. We're in the Wild West days for a while. Now law and order is in town, but we don't have Wyatt Earp riding the range anymore. There will come a time where this will be pretty standard. So it doesn't make a lot of business sense to put it off. And you're certainly another risk you should consider is the False Claims Act.
Makes sense.
And again, I'll say, go to your contract. What does your contract require? And is it believable the way you're interpreting it? Not can you come up with a tortured interpretation, but is what you're doing a reasonable interpretation of the NIST standard?
Right. Okay. Yeah. Well said. Well, Julie, I really appreciate you sharing your expertise and insights with us today. I can go on for another 3 or 4 hours asking you questions, but I know you're a busy lady, so you have work to do. Do you have any closing words for the audience?
I would just say that if somebody out there is struggling with this, please do give us a call. It's a free consult. It's completely confidential. I may be able to set your mind at ease, either by saying, hey, don't worry about it, or by saying you can't do anything about it this way, or by saying, yeah, we need to report this. It's a free consult and it's a free lawsuit. You're not going to be, I'm a contingency attorney. So don't let any of that hold you back from getting a consultation on this stuff. It's really our mission to make sure that government information is protected. I think it's just, in all seriousness, it's terrifying to think about what could be out there, what could be accessed.
Right.
It's not, I'm a child of the 80s. So the idea that Russia can get into our stuff, that China can get into our stuff, all of this is very concerning. And I'm more than happy to help anybody who has questions about that.
Stakes are definitely high. Well, thanks, Julie. Really appreciate it.
Thank you.
If you receive value from this episode, I invite you to subscribe and like so that you're the first to know when we release new episodes. Also, check out CMMCproof.com to learn more about the arsenal of resources that we provide to equip you to conquer CMMC. We'll see you next time.